So when you're considering state income tax, I think the number one issue is that your state taxes are going to go up both as a percentage of your total U.S. tax burden as well as a gross amount. For the first item, 5% effective tax rate for states, pretty common rate. 5 plus 35%, 40, it's over 10% of your total rate. But the 5% is really a 7.5% tax affected at the 35% corporate rate. By the fact that the corporate rate is dropping down to 21%, that 5% rate goes up to 6%. And it's 6% over 27%, which is over 20%. So just by virtue of the corporate federal rate going from 35 to 21, your state rate is going to go up a point and double as far as a percentage of your total rate. However, it's also going to go up substantially due to the base broadening measures that most of the states will adopt, but they'll keep their own state rates static. So they're going to go up as a total amount as well as a percentage of the total tax. There's been a lot of press lately, a couple articles in the Wall Street Journal. The Committee on State Tax just put out a review that states are expecting substantial revenue gains due to tax reform. Now, in the inbound context, probably the biggest issue is financing and the new 163J limit. States are most likely than not going to adopt this 163J limit either through rolling conformity, those states that have that, or through their legislative sessions. They'll most likely, many will adopt the 163J limit. The thing to think of in this aspect is for federal, that 163J limit is most likely going to be computed on a consolidated basis. Now, states don't really follow consolidated concepts, so the risk, and I think really the reality, is many, if not most states, will do a separate 163J limit on a standalone basis. And I think that has a potential to severely harm companies because it's a very common fact pattern where there's a holding company with no operations in it where the public debt is at. And if you do that on a standalone basis, you're going to have 30% of zero is zero and have your interest expense completely eliminated. Now, some of the other provisions, the same concept of looking at these calculations on an entity by entity versus a consolidated basis, you have to keep in mind, related to some of the 250 deductions related to FDII, under Section 250, as well as the 250 deduction under the GILTI provisions. There is a overall limit in those sections that they can't exceed taxable income. That's going to be, again, for federal. They can't exceed the combination of the deductions, exceed your consolidated taxable income. And again, most likely there's a risk that states would make you relook at that combined 250 limit on a separate entity basis as well.